Hello, everyone. Welcome to our webinar. While 2020 was an impactful year for everyone, the Patent Trial and Appeal Board has been busy. They've designated numerous decisions and implemented procedural changes that affect AIA Trial Practice. So we are excited to discuss them with you today. If you have any questions, please type them in the chat box on the side, and then we'll be going through the questions at the end of the presentation. On the days following the presentation, a recording of the webinar will be available on our website. And with that, let's get started. So, my name is Andy Turner. I am the co-chair of the BK Post-Grant Proceedings Group, and my practice also includes patent prosecution. Joining me today is John and Reza. John, why don't you tell us a little bit about yourself?
Hello, I'm John Rondini. Like Andy, I've had quite a bit of experience handling multiple IPRs and CBMs before the PTAB. I have been with the firm just over 12 years. I'm a litigator for the past roughly 10 years and also handle some patent prosecution. Reza, why don't you introduce yourself?
Hi, everyone. Thank you for joining us today. My name is Reza Esfahani. I am an associate at BK. I'm primarily working in intellectual property litigation group, but I also do patent prosecution.
All right. Thanks, gentlemen. All right. So with that, this is a little overview of what we're going to discuss today. First, we're going to go through some statistics, both PTAB numbers and at the different district courts. We're going to discuss some rule changes and clarification memos from the PTAB, some recently designated decisions on various topics, an update on the motions to amend pilot program. We're going to give some updates on Arthrex. There's another Supreme Court decision on appealing institution decisions. And then also, just a note here, there are no updates to the trial practice guide in 2020, but this is a great resource. So we have a link here, and we're going to reference the trial practice guide throughout. And also, when you see, we have a bunch of links in the slides, which we sent out beforehand, and we'll also make these available on our website. So hopefully your hyperlinks work. So with that, we're going to start with some statistics. So first, John, can you go through some filing trends for us?
Sure. Well, interestingly, with everything that happened over the past year with regards to the pandemic, it was an interesting trend with regards to patent litigation. It bucks a trend over the past 5 years. Over the past 5 years, we've seen patent litigation dropping. It actually dropped quite significantly between 2015 and 2019. It was almost a 40% drop. Last year was the first year since 2015 we've seen a rise in patent litigation, and we saw a rise in a lot of the different forms across the nation, but in particular we saw a big rise in the Western District of Texas, which we'll talk about in a couple minutes. And as you can see, the trend was not only in district courts, but it was also there was a rise at the ITC filings. They were up 30%, and as we'll talk about in a minute, we also saw a rise in the PTAB filings, which makes sense. As the rise happened with district court litigation and ITC filings, we saw the similar rise happen with regards to PTAB filings. So overall, the trend was upward last year for patent litigation. Right now, the trend, in the first month of this year seems to be continuing on course. We're seeing quite a few patent cases coming in since the beginning of the year. So it looks like moving forward into 2021, we'll probably see, another significant rise in patent litigation.
Great, thanks, John. So here we see, with the PTAB, we see over 1,500 cases last year. Reza, can you break that down for us for the PTAB filings?
Yeah, absolutely. So as you can see, the number of IPRs filed are still substantially higher than the PGRs and the CBMs. The CBMs are, consistently low. There've been only 15, and last year there's a sunset, so there will not be seen any more of those. PGRs, however, about doubled last year. That could be due to the fact that there are now more AIA patents out there as it applies there. And, there's a change in trend with the IPR filings, and that could be attributed to the fact that litigation was up in general in 2020. So that's why we see that rebound between 2019 and 2020.
Great. Thanks, Reza. So how about, John, can you give us a breakdown on some of the district court filings?
Yeah, as I mentioned a second ago, we saw quite a significant uptick in district court filings. The biggest player, of course, as most are probably aware, was the Western District of Texas, where we saw a very significant increase in filings over the past probably last 2 years. And, a lot of that has to be attributable to Judge Albright coming and setting up, a new set of patent rules, basically coming in and going across the nation and basically trumping up patent litigation business for the Western District of Texas. So while there was some other forums that still remained high on the list, including Delaware, we saw the biggest uptick from 2019 to 2020 being the Western District of Texas. And if we move to the next slide, you'll see that trend in this slide from Docket Navigator, where not only do we see a trend upward in the Western District of Texas in terms of filings, the reason there was an uptick in filings was because of Judge Albright's rules and the fact that when he went around, he basically stated not only was he going to make patent trials a priority there in the Western District of Texas, but he was also going to make it a quick scheduling. So what we've seen over the course of the last 2 years since Judge Albright's, taken over there, is we've seen a very quick scheduling of patent cases from filing to time to trial. We've seen, and we'll talk about this a little bit later in the presentation, we've seen a lot of the milestones, the big milestones like claim construction orders, summary judgment motions. Those are all happening at a very, very rapid pace there. So for patent owners, it's now turned into what the Eastern District of Texas was a couple of years ago. It's the new essentially rocket docket, which now you have a couple of those different venues around the nation, including Delaware. But Western District of Texas is now probably the fastest. And another interesting trend there was when Judge Albright was going around, he knew the dichotomy with respect to patent litigation filing and then the IPRs being filed at the PTAB and people seeking a motion to stay. And one of the things he stated was he wasn't going to go and just grant a motion to stay outright if an IPR was filed. And we've seen that trend come to fruition. And when you look at the stats for motion to stays pending IPRs, we've actually seen them start to decline over the past year. In 2020, you can see it was almost 60% of the motions to stays that were filed were denied. And a good majority of those came out of the Western District of Texas, where they were denied based primarily on the stage of the litigation and how fast things move there.
Thanks, John. So this isn't just one court. These are all district courts that are.
Yeah. So the top chart shows all the district courts, and it shows the time to completion on a lot of those. And we see the Western District of Texas is one of the lowest, and it keeps trending downward. And we have a stat later on to show how before Judge Albright was there, it wasn't that quick. And in the 2 years that he's come to the bench and implemented these patent rules and basically stated he wants it to be a quicker docket, we started to see all the numbers in terms of length, but months to a certain milestone, significantly drop.
Okay, great. So next up, we have some statistics on IPR institution rates. And we're going to discuss discretionary denials at length today. But institution rates, this is, after filing an IPR petition, are they granted or denied? And we see here, they've been, since at least 2015, institution rates have been pretty consistent at the PTAB. I mean, they've stayed between about 59 and 65%. And again, this is just IPRs. I didn't put the graphs here for CBMs and PGRs because those much small, lower sample size, those numbers are not quite as consistent. And again, these are docket navigator numbers. So if you like to use the PTAB generates similar data, but they go off fiscal year, the US PTO fiscal year, and these are calendar year dates, numbers. So with that, we're going to a little PTAB housekeeping. So here, the PTAB issued a memo late last year on applicant admitted prior art and how that's treated for IPRs. Just a clarification memo that applicant admitted prior art, it can't be the basis of an IPR. It's not a patent or a pub under section 311, but it can be used for a number of different things, such as supplying missing claim limitations that are known in the art, support motivation to combine, and also to demonstrate the knowledge of a person of ordinary skill in the art. So one, we see this might affect some of the arguments that patent owners make as far as hindsight bias. So over the last few years, we've seen a lot of times if the challenge patent is referenced, even kind of in passing in a rationale to combine, sometimes we would see some hindsight bias arguments that the PTAB would seem to entertain. And here, I think this will help at least give petitioners something to cite that it is permissible to cite the challenge patent and kind of rebut some of these hindsight bias arguments. Some other updates are there's some rule changes last year, and the PTAB kind of grouped these into a couple rule packages. The first one, part one, and these aren't really surprises, right? These rule changes are things that we've been, some of the practice that we've been using the last few years, but now they've codified them. So the first group is codifies SAS, which is a Supreme Court decision that we all talked about a few years ago, that the PTAB will institute on all claims and grounds. The second one had to do with SIR replies, replacing observations. So that practice, that was a couple of years ago. Basically, observations were kind of an obscure, kind of cumbersome practice, and they were replaced with SIR replies. Another one here was they eliminated the presumption in favor of petitioner at institution. And this is a practice where I think it was kind of meant to encourage patent owners to file expert declarations with their preliminary response. So if they eliminate this presumption as a way to kind of encourage patent owners to submit more testimonial evidence. The next group had to do with clarifying aqua products, or sorry, codifying aqua products. And this was clarifying burdens in the motion to amend practice. Aqua products was a Fed Circuit decision from a few years ago. And then the last one here, this had to do with a rule about the board raising new grounds of unpatentability for substitute claims in rare circumstances. So this codifies Hunting Titan, which was a POP panel decision last year. So pardon my background if you can hear all that. So.
Andy, real quick before we go on, I'm getting some feedback on that.
No.
So there was a couple questions that came in with regards to CBMs, and just wanted to quickly before we moved on, just touch on those. Someone asked about the sunset of CBMs and what was the conclusion. The sunset was basically the end of the term of the CBMs was last September. We'd seen a drop off in CBMs quite significantly based on some of the past decisions that had come out over the last couple of years with respect to, what would fall under and not fall under the CBM. So it wasn't surprising near the end of the CBM length, which was last year, we had been seeing them decline quite significantly because they were getting denied an institution just simply because there was any aspect that got it outside the CBM or outside of a CBM allowance or institution, then they were getting denied. So many people weren't even filing CBMs anymore. Was there enough cases to evaluate? Not over the last 2 years because of the significant drop we've been seeing. CBMs just, they kind of hobbled into the, that sunset provision last year. They were falling off, quite significantly over the last couple of years. And then the last 2 years, we basically saw them just kind of hobble into the finish line. So, and is there any talk of the USPTO or legislation to revive the CBMs? Not at this time. I mean, there was a little bit of talk, I think about 1.5 years ago, but we haven't heard really anything with regards to trying to revive it. It was one of those, it was always supposed to be temporary to try to get rid of some of the, what they considered to be ineligible patents that were filed and granted back in the early 2000s. And it was meant to try to clean up some of those. I think they're going to stay the course and not bring it back now that we're falling into the AIA window of patents post 2013 filings, and people have the option to file a PGR as opposed to an IPR. If you want to file a PGR has a lot of the mechanisms that the CBMs allowed you to file. It's bigger than an IPR in terms of just printed publications. So I think the way the legislators are looking at it, and there's not really a push at the patent office to revive it. I think they're looking at it is if you want to file something with regards to some of the other aspects beyond printed publication, PGR is the mechanism in place now, and many of the patents are being issued now since they're post AIA patents. That's the avenue they want to keep moving with in the near future.
All right, great. Thanks, John. So on just a note on these rules, I think the PTAB has a board side chat this week. I don't know if you guys attend those, they're quite informative, and I think on their agenda, they're going to go through these rule changes in a little more detail. So next up, we're going to get into some of the decisions that were designated in 2020. And the hot topic is discretionary denials of institution. So the first one here, this has to do with prior examination. So under 35 U.S.C. 325D, the board may deny institution because the same or substantially the same prior art arguments were presented to the office. And this basically from the statute, the board developed a bunch of factors that they will consider. We refer to them as the Becton-Dickinson factors. And these, we've discussed these are a few years old. But now, Reza, any updates on 325D in 2020?
Yes, absolutely. So in 2020, in a case called Advanced Bionics, decided in 2020 and designated in 2020, the board sort of trimmed down that 6-factor test into a 2-part test, but still does evaluate those 6 factors under the umbrella of these two-pronged tests. The first prong is essentially verbatim what the statute says, whether or not the same art or substantially same art was previously before the office. But the second one says, and if that was the case, whether there was an error, a material error to patentability established by petitioner. For error, they kind of left it very broad. They say that what constitutes error is that it must be clear. If reasonable minds can disagree over what the art or the argument is, then that does not necessarily show an error material to patentability. After that, but two other decisions were also designated in 2020 at the same day as Advanced Bionics. One of them was the Puma case. That one was designated informative. In that one, the board emphasized the overlap in arguments between the art that was before the examiner and the art that was cited in petition. They were the exact same art, and the office denied institution on that. In Auticon case, which is a presidential case, unlike the other two, the office did not deny institution, and one of the petition had relied on 2 grounds. One of the grounds was previously before the examiner. The other ground, however, was new, and the office found that to be non-cumulative or substantially similar to what previously had been examined, and instituted the IPR. This case also had a 314 component regarding parallel litigation with the district court, and Andy will talk about that aspect of it.
Great. So thanks, Reza. So before we get to the parallel litigation side, just a quick practice tip. When you have these 325D issues, practice tip here is to review the full file history. So this, a lot of times, when we look at the file history, we'll download the free version from the Patent Office website. And that does not include documents that are called NPLs, non-patent literature documents. So what you can do is you can either order the full file wrapper from the Patent Office, which is relatively inexpensive, but it takes about a month. Or there's different services where there's some companies in DC that'll go and copy these for you. But these NPL documents, sometimes they'll include things like claim charts from litigation, foreign search reports, different things that have golden nuggets in there that are helpful when you are reviewing the file wrapper. So it's important to review the file wrapper of not only the challenge patent, but of related patents. So that's a little practice tip. So next up, we have, here's parallel litigation. So here under 35 USC 314, generally the board has discretion to deny institution under 314. And the trial practice guide a few years ago highlighted the fact that the board may deny institution based on events and other proceedings related to the same patent. And then there was the NHK case that was designated a few years ago. And in that case, they said, okay, the advanced state of the district court proceeding is an additional factor for the board to consider. So what is an advanced state? So basically what we're talking about here is when a defendant in litigation, this is like a forum selection type analysis. So as a defendant, using the PTAB as a supplement to litigation instead of an alternative for challenging validity. So if it's clear that they're using it as a supplement, litigation is already in advanced state, it's far along, then the PTAB is more apt to deny institution.
And just real quick before we move on, Andy, I was just going to point out with regards to 314, a little note / practice tip with regards to what Andy has highlighted there, whether the events and the other proceedings are related to the same patent. And the way that the USPTO and the PTAB have taken that is it actually means the same patent. So if you have a patent family with quite a few, grandchildren off of it, and the original parent case was attacked, and then a great-great-grandchild later on was attacked, that is not the same patent. And the PTAB has come out and said that this argument's been made for 314 in some cases that have come out recently. And the PTO has come out, or the PTAB's come out and said, no, when you're attacking a grandchild or a great-grandchild or, an uncle or cousin, that's not the same patent. So the 314 analysis doesn't apply in those situations. So that's just something to keep in mind when you're, thinking about raising a 314 or you have a 314 argument being raised against you with regards to, a patent or a patent family.
That's a good point, John. Good point. And that's, so this is kind of a little background. So now, Reza, can you give us an update on some new decisions on this parallel litigation?
Yes, absolutely. In 2020, again, another 2020 decision that was also designated in 2020, Apple versus Fintiv, the board elaborated on the 314 and set forth six non-exhaustive non-dispositive factors that they evaluate to determine whether or not they should institute. These factors, the first one is whether or not there's a stay in the parallel litigation or whether it's likely that there will be stay in the parallel litigation. How far is the trial, or in other words, whether or not the final written decision is due to come out after the trial. The third one was an investment of the parties and the court in the parallel proceedings. The fourth one is concerning the overlap of issues, whether or not if the issues are decided in the PTAB, are they going to substantially get rid of the issues that are before the district court? The fifth one are whether or not the petitioners and the defendants are the same party, or the petition's been done by somebody else. And the last one, just other circumstances like the merit, if they think that it's meritorious to evaluate. We had a couple of cases that apply these, which kind of gives us an idea about which one of the factors are more important. So far, one of the factors that we've seen is very important is the second factor, which was the proximity to trial. They take that one very seriously. If they figure out that the decision, the final written decision is going to come out after the trial date, they're likely to deny institution. In the other two cases, the SNAP and Sotera case, they also weigh in on two other factors. The first one, in the SNAP one, they said that there's a stay already in place in the district court, and that weighs heavily against denial. The Sotera case, on the other hand, said, you know, that the defendant the petitioner put in a big stipulation or broad stipulation in the district court, and they found that stipulation to weigh strongly against denial.
All right, great. So that means stipulations. Can you expand on these a little?
Yeah. So, you know, we kind of got what the stipulations are. In the Sotera case, which the board found the stipulation to be very broad, the stipulation was essentially that the defendant will not pursue any ground essentially under 102 or 103 if it is instituted by the board. So that's very, very broad. In another Sand Revolution case, that one is an informative case. The stipulation was much narrower. In that one, the stipulation was that they will not pursue on the same grounds. So, and interestingly here is that in both of them, they reached the same the same results. So, sort of the practice tip here is that, you know, you don't have to go as far or as broad with the stipulations.
By reaching the same result, you mean as far as institution?
Right.
So they instituted on both.
Right.
Good. Great. All right. So to kind of illustrate the parallel litigation examples, we created a little cartoon here. So first off, in this example, we have a standard district court. So this is your standard district court, like some of the examples John listed earlier, where the trial date is over 1,200 days after filing. So now we have a petitioner who waits until the last day possible, which is their 1 year date from when they were served with the complaint, to file their petition. So that's our procrastinator petitioner. So this is the case where petitioner files. Now an IPR trial takes about 1.5 years from filing the petition until the final written decision. So you see here, even though they waited 1 year, there's still plenty of time, right? So this final written decision is going to issue, you know, 300 days before trial. So then this isn't quite a district court is not in such an advanced state. But now the second example here, now we get into, you know, some of the rocket dockets that John was talking about earlier. So here we see the time to trial for some of these cases is much shorter. We're looking at around 600 days. So now if it's at 600 days and you are a petitioner who waits until the last day possible to file your petition, you wait till 1 year, you see here, now your final written decision would issue, you know, a couple hundred days after trial. So now at the PTAB, there's a much stronger parallel litigation argument, right? This litigation is much farther along. It's an advanced state. They go through some of the factors that Reza just outlined, and you're more apt to get denial here, denial of institution. So what do you know, if you find out you're in a rocket docket jurisdiction, what do? So one approach is, well, you got to try to get your IPR on file sooner, right? So here, instead of waiting until your 1 year deadline, if you file within the first few months, your final written decision is more in line. If you can get it in line with the trial, you have a better chance of it not getting denied under this parallel litigation. So with that, John, now we talked about the time to trial. Can you expand a little bit more on some of the other dates for these rocket dockets?
Sure. So tying it all back to the 314 and Fintiv factors, what we've seen over the past couple of years is, and especially now that Fintiv's come out with their factors, it's not venue neutral. And here we have, just some statistics from the Western District of Texas, as I talked about earlier. And, due to the pandemic last year, there wasn't a lot of jury trials. So we really don't have a lot of those numbers coming in yet from when Judge Albright's kind of taken over in 2019 to present, which is the lower set of stats. But up above, you can see from 2010 to 2018, before he took over, the median time in months it took for a claim construction order to come out was 17 and a half months. Now we're seeing that drop. We've seen almost a 7-month drop. It's down to just over 10 months. And it probably will continue to drop as, the Western District of Texas continues to issue orders and move forward with their proceedings as quickly as they have. And as Andy was just explaining, with the Western District of Texas being the new hot rocket docket, it's not the only one. We have the Eastern District of Texas, which is still a very fast forum. We have Virginia, Delaware. We have quite a few forums now that are very fast, or these rocket dockets. And what we're going to start seeing, and what we've already started seeing over the last year and a half, is forum shopping. I mean, the plaintiffs are recognizing this fact that if they can get into a docket that has a very quick scheduling order, where from the time of filing to the time of some of these big deadlines, such as claim construction orders, summary judgments being heard, end of discovery, and even trial dates being set, under the Fintiv factors, you're going to start hitting on a lot of those factors, and you're going to see the discretionary denials be granted for those forums. And we've seen that. We've seen a rise in the number of denials with regards to litigation that was going on in the Western District of Texas. That's why we're throwing up this stat, is because that over the last probably year, the biggest number of denials on institution, once the Fintiv factors came out, was with regards to litigation in that forum. So what we're going to just see is we're just going to see a continual rise in plaintiffs trying to file there. And, with the ease that it is to file there, you don't necessarily need local counsel. It's very easy to get admitted there. And because of that, attorneys and counsel outside for patent owners outside of the Western District of Texas are getting admitted there, and then they're filing their cases there because it's such a popular forum. So that's one of the troubling statistics we're seeing. It's not the worst thing, as Andy just mentioned in his previous 2 slides. All that means is if a lawsuit is filed in one of these forums, you have to stay on top of it. You can't necessarily wait until the statutory 1-year deadline, because if you wait that long, it's very possible you might be denied institution just under the Fintiv factors, the 314 factors. So if it's filed in a very fast forum district, then you're going to want to get on top of the IPR and try to get it filed as quickly as possible in order to avoid a discretionary denial. You're still muted, Andy.
Thank you. So it'll be interesting to see if these courts can keep up their pace, right? See if Western District of Texas can keep this aggressive timeline.
That'll be the interesting thing with the huge rise there. It probably will follow the pace of some of the other rocket dockets, where it will slow down a little bit until they can push through some of the cases, and then we'll hit some equilibrium. And in probably about a year or two, we'll know what the real numbers are there in terms of how fast it moves.
Okay, great. So that was parallel litigation. So now some other decisions designated last year had to do with the real party in interest. So here, so the first case, the Sharkninja case, this is that basically the PTAB said failure to name an RPI, it's a curable offense, right? If there's no time bar or estoppel issues. So they need not address whether this party was an unnamed RPI, because even if it were, it doesn't create a time bar or estoppel issue. Now this RPX case, this is this is an interesting case, and this is where the board expanded this RPI analysis for member organizations. So member organizations, these are organizations like RPX, where you join a group. and they'll file IPR petitions. So typically when we talk about RPI, we focus on control and funding. But there's another factor that's listed in the trial practice guide that has to do with the nature of the petitioner. And this, nature of the petitioner and their relationship with an unnamed party. So in this decision, the PTAB went through quite a few additional factors that had to do with this whole relationship. And I think this actually came back on remand, and the Fed Circuit listed these factors. I think they might have came from another body of law like agency law. But what's interesting here, my dog barking is interesting too, if you can hear that. So, must be the mailman coming. So anyway, but what's interesting here is they go through all this real party and interest analysis, and the board ultimately determined that this unnamed party was an RPI and they denied institution under the time bar provision. But another interesting point here is after they go through all this complex RPI analysis, they said, oh, by the way, they went through privity analysis and they said privity is broader, but we don't really need to decide on it because it was not raised timely, right? I think patent owner raised it at the oral argument, which was too late. And then after that, the PTAB also went through 314 analysis for a serial petition. And they kind of went through serial petitions, and there was a case that we discussed a few years ago about Valve Corp. We're expanding the general plastic factors to another party. So even though they didn't decide on these issues, the board kind of outlined different strategies for attacking these petitions. So that's kind of some interesting analysis in here, and kind of beyond our discussion for today, but we're planning a blog post on this one, so stay tuned. So next up, we have secondary considerations of non-obviousness. So this is, I think there were some decisions last year. John, can you tell us about Lectrosonics?
Lectrosonics, no, it's a mouthful. So Lectrosonics was designated as precedential last year, and it kind of plays off of what we talked about last year in terms of our year-end review for 2019, and that was with regards to the Fox Factory v. SRAM case, where the Fed Circuit kind of came out and they laid out a pretty nice summary on the evidence of secondary considerations in terms of non-obviousness and how it's accorded some substantial weight and what type of weight and how to evaluate it and under what circumstances. And it laid out a very nice set of factors. And, based on that decision, the PTAB last year designated this as a precedential case. And in this case, there was a patent owner that, submitted evidence of secondary considerations of non-obviousness post-institution. During that time, they were also looking to amend the claims of the patent, and they likewise argued their evidence of secondary considerations of non-obviousness supported the patentability of the claims that they were seeking to add as amended claims. And here it was interesting. The PTAB, for the original set of claims, basically said that they were unpatentable, and the evidence submitted for the secondary considerations didn't support non-obviousness, and they still invalidated the claims. And the reason was not so much the evidence that was presented, but the fact that the evidence that was presented was holistically about the patent or what the specification described about what they thought the invention was, but it wasn't what was claimed. And that's what the PTAB really locked onto, was when you want to submit this evidence and you want to try to use secondary considerations, it's got to be, about the claimed aspect. There's got to be that nexus to the claimed aspects, being recited. And for the amended claims, the PTAB came out and said, you're right. The secondary considerations of non-obviousness, the evidence you presented, is tied. There is a nexus to the claimed features of the amended claims, and that supported a ruling of non-obviousness. So the amended claims were found to be non-obvious and allowable, whereas the originally presented claims were found to be obvious, and the secondary considerations didn't pull them back into a non-obviousness type of realm. So here they got some claims out, some died, but the big key and the big reason this was marked as precedential was the analysis based on the Fox factory and how the PTAB went through the Fox factory analysis. They did it for both the original claims and the amended claims, and showed one was tied to the claim features, one was not, and therefore one set is patentable and one set is still non-patentable. So moving forward, one of the aspects, if we move to the next slide real quick, Andy, not only was this one marked as precedential, interestingly, can you move forward, Andy? Oh, you move forward. Interestingly, in the same month, the USPTO came out and they actually marked 2 cases as informative. It was actually one was just a little over a week before the Lectrosonics case, and one was on the same day as the Lectrosonics case. As you can see, that's the ex parte Thompson. And what's interesting here is the ex parte Whirlpool Corporation case that was marked as informative was a case that was decided back in 2013. The ex parte Thompson case was decided in 2014. And both these cases, while they're prior to Fox Factory, they kind of followed the Fox Factory analysis, and they focused in on the claim feature and showing the nexus. And these are marked informative because under both of these, there's a large analysis about what type of evidence was presented, what type of evidence is supportive of the claims, how it was supportive of the claims, and under what terms it would pull it back from being non-obvious based on the secondary consideration evidence presented. And moving forward, I think based on the precedential decision we have and these 2 informative decisions, I think you're going to start to see a rise. I mean, I've already seen it in a couple of cases I'm involved with, a rise in patent owners trying to argue, presenting evidence or trying to get evidence in of secondary considerations. So this is something, if you're, on one side of the V and the patent owner is in a district where they can get discovery early, what we're seeing is they're trying to use some of that discovery. They're trying to use or bring in other discovery and bring that all into the PTAB IPR setting and trying to argue some of the secondary considerations of non-obviousness, since that is the primary attack on most patents once an IPR is filed. Usually it's not 102, usually it's a 103 argument. So we're starting to see a rise in patent owners trying to present evidence and make this argument, trying to get that nexus. And I think under these decisions, you'll start to see even a larger increase now that patent owners kind of have guidance on how to do it.
Well, that's interesting. Yeah, usually secondary considerations is discussed in passing at the end of a brief, but it's becoming more prominent. And it's nice that they're designating these old decisions. They're finding some gold in the old archives.
Yep.
All right. Thanks, John. So next up, we have some updates on the motion to amend pilot program. So here, we discussed this at length last year, but basically with this pilot program, this gives patent owners some feedback from the board on their motion to amend, and then they also have the opportunity to revise their motion to amend. So this program went into effect in 2019. Basically, with the 2 main options here are the patent owner requests preliminary guidance on their motion to amend. So they file motion to amend, they ask for preliminary guidance, some feedback from the board. Now, based on that preliminary guidance, they can either just file a reply, keep their existing motion to amend, or they can file a revised motion to amend and make some updates, revise the claims further based on this feedback. And one interesting point here is when you do file the revised motion to amend, they do adjust the schedule a little bit. They bump the hearing out another month, and there is additional briefing here, so it can get pretty compact. Now, there's also the option 3 and 4, which I don't have shown here, but either the patent owner can just not respond to the preliminary guidance, or they can actually withdraw their motion to amend. So here we have some success rates. So the former director issued a blog a few months ago just with some numbers on the success. So under the pre-pilot program, the success rate, where at least one of these proposed substitute claims was granted, was pretty low. It was at about 14%. But now under the pilot program, they looked at some of these from last year, and they said that they were up to about 36%. So we do see an increase in the success rate under this new pilot program. So there was also an interesting decision last year on motions to amend. So this was Hunting Titan. So Reza, can you tell us a little bit about Hunting Titan?
Yeah, Hunting Titan was a case decided by the Presidential Opinion Panel. And essentially, it found that the PTAB can only, in rare circumstances, sua sponte, raise new grounds against the substitute claims in the motion to amend. Didn't necessarily really explain what rare circumstances are. I think some of the examples they had was if a petitioner ceases to participate in the motion to amend, or chooses not to oppose the motion to amend, or if there is an evidence that the amendment is on its face unpatentable. That being said, going the route of motion to amend does open the door to other challenges that Andy will discuss now.
Okay. And just, a quick comment on Hunting Titan. I mean, this isn't a drastic change. The board wasn't going out and conducting, a search for new references. Basically there, they just switched from a obvious ground to an anticipatory ground. So wasn't a drastic change. And then also, as far as, just kind of a reminder that when you file a motion to amend, you open the door to other challenges, that aren't, under normal IPR process, such as challenges under 101 and 112. For example, the Smartmatic case is a good example of when the substitute claims were found unpatentable is indefinite. And this are actually indefinite as lacking antecedent basis. So this is in the preliminary guidance, amongst a variety of different issues. One of the things was the board said, hey, these certain new substitute claims, they're indefinite, they're lacking antecedent basis. And then here, the patent owner did not correct the claims. They did not file a revised motion to amend. So then when it came down to the final written decision, the board said they're indefinite. So that's just a little reminder that, keep in mind that once you do file a motion to amend, you open the door to other challenges. And when the PTAB gives you some feedback in that preliminary guidance, pay attention. So next up, we're going to talk about constitutional issues and statutory issues. And first up, we have Arthrex. So John, can you give us an update on Arthrex?
Sure. Just real quick, I mean, I know Arthrex has been talked about a lot over the past year, but this was in regards to the judges, the APJs, and the whole system, and whether it complies with the U.S. Constitution's appointment clause. So this was an argument that Arthrex raised, at the Fed Circuit on appeal for the first time, and the Fed Circuit, considering it such an important question, took it up and came up with their decision last year. Well, that's since been they filed cert last year to have the Supreme Court hear the case. The Supreme Court agreed to hear the case and has since, in the last 2 weeks, stated they were going to put it on for the spring term. So it's going to be heard. Arguments are going to be heard in the spring. So we should have a decision on Arthrex this year, which will be interesting to see, what the decision from the Supreme Court is in terms of whether the judges and the constitutionality of them, and whether it's going to affect, IPRs that have already been decided. What's it going to do to the system? So it'll be interesting to see, how the Supreme Court handles this case. As you can see, the court has agreed to hear 2 aspects of the 3 aspects that were raised, at the cert level. And it's basically whether the PTAB judges are properly appointed under the appointments clause, and if not properly appointed, whether the Fed Circuit's removal of the employment protection, fixed the alleged defect with regards to the appointments clause. So that'll be something that we'll keep an eye on, and as soon as a decision comes out, we'll send out a client alert and let you all know.
Yep. So coming soon. All right. So next up, there was another decision the click to call case. So Reza, can you tell us a little bit about click to call?
Yeah, so click to call case was a Supreme Court case decided last year. And essentially the US Supreme Court decided whether or not the board's decision to institute after finding that the petition was not time bar is appealable or reviewable and appeal. And the court essentially said that the section 314 that prohibits review of PTAB decisions to institute applies uniformly, and it also applies to their decision of whether or not the petition is statutory time bar.
Okay, great. Thank you, Reza. So with that, for 2021, we're going to discuss some cases to watch and some of our bold predictions. So first up, Arthrex. Anything else to add on Arthrex here, John? Or
no, I mean, it's just one that it'll, like I said, I mean, the biggest thing to watch will be not only what comes out from the Supreme Court in terms of the constitutionality of the judges, but how it's going to affect IPRs that are ongoing right now, IPRs that have just been recently decided that are on appeal. You know, how the decision comes out is going to really affect. It could be, just an avalanche in terms of all the cases that are out there right now, or they could just agree with the Fed Circuit and it becomes not really that big of an issue. So it's going to be something just to watch in terms of if you're involved in an IPR or if you're involved in litigation and are about to file an IPR, you want to keep an eye on that because it may or may not affect you depending on what the Supreme Court does.
Right. And sometimes we've seen this over the last few years when a big case comes out for pending IPR, sometimes the board will issue memos in the pending cases and say, okay, here's you can they'll allow supplemental briefing to address a certain issue. Yep. Or, some type of memo. So that's, as far as our predictions, the PTAB is probably already reviewing these and they have some memos, depending on which way the decision comes out that they'll release. Another case to watch was Minerva Surgical on assigner estoppel. So this is.
Yeah, this is an interesting case, essentially asking the Supreme Court to, like the licensor estoppel, which was abolished in Lear versus Atkins, to also abolish assigner estoppel, which will have some impact on patent litigation. So that's a case that will be, keep an eye out and let you know when it comes out.
Okay, great. So now some of our bold predictions here. This is, we just mentioned some of the things, some PTAB solutions to Arthrex. Another one is we've seen in some of these other areas where the board likes to start with factors and then eventually distill it down to some type of test, maybe not exactly a bright line rule, but distill these factors down. So that's something we see right now. There's all these Fintiv factors, and there's some cases coming out where some factors are being emphasized. So that's a prediction there that we're going to see a test.
Then with regards to with regards to the Western District of Texas, I think we talked about this earlier. I think a prediction is we're gonna see a slowdown at some point until it can hit an equilibrium. Right now, it is the fastest docket by far in the U.S. and it probably won't slow down in the first couple months of this year, but as more and more cases get filed there, it's just bound to slow down somewhat over the course of this year. To what degree is undetermined. I guess it all depends on how many cases are filed there, but we will see a slowdown and that's going to affect the Fintiv factors that Andy was just talking about. I mean, if there is a slowdown there, then there's the possibility that the discretionary denials that we've been seeing on the rise might slow down a little bit based on the slowdown in the district. So until they hit an equilibrium, we won't know to what degree, the Fintiv factors are really going to be affecting, petitions filed.
All right. And then, so we see that WD Texas is popular now. It's the place to be. So the question, do any other judges want, will we see any copycat rocket dockets?
Well, I mean, this is a copycat rocket docket. I mean, ED Texas was the original, and then, we had a couple pop up like it. Judge Albright, who was a patent litigator for 20 years, went around and said he wanted to make it a popular patent forum and make it into a rocket docket. So I guess the big thing is, whether the bench, if there's new judges that come in under the new administration, whether they are patent savvy judges. As we've seen around the nation, there's some forums that like to have patent cases, or some that do not. And the ones that are slow typically don't like to take on patent cases. But if new judges come in like Albright, who, have a tendency toward patent cases, I think we are going to see some copycats. And there's, very likely there's going to be quite a few positions filled. So we'll just have to wait and see who fills those positions around the nation.
What do you think about Michigan? You think we'll see a rocket docket Michigan, John? No?
Oh, no. I mean, there's a reason that this, the saying's always been, this is where patents go to die. I mean, it's one of the slowest forums in terms of patents, that they've just never had a tendency to want to take on or push patent cases forward. So it's possible. I mean, we've had, we have judges that will be stepping down over the next couple of years. So it's one of those things where I think it's a forum that could be very much like WD Texas in terms of a rocket docket, because you have a large industry base here with the automotive industry, and you have a lot of players here supporting the automotive industry. So it is a forum where there's a lot of companies here. So, if the bench decides they want to take a bulk of these cases that are now in Western District of Texas and Virginia, ED Texas, that would be the way to get those cases here, is to make it more patent friendly. So it's possible, but right now it's, unlikely with the judges.
Right. And Michigan, it's not the nicest place to visit this time of year anyway.
Yeah.
But we're all virtual, right? So and the last one on our predictions, this is more wishful thinking, but this is the trial practice guide, which I mentioned earlier. We haven't seen an update in a while, but I'm hoping they do. It's like an MPEP for post-grant. So I think that's all we had. And I guess, do we have any more questions coming in?
I don't see any.
All right. I guess with that, we'll thank everybody for joining. And I do have my closing statement here. So thanks everybody for joining. Our slides, or actually this recording, like I mentioned before, we'll post it on our website. We sent our slides out, but if anybody didn't get them and they want them, you can send us an email. I think those should also be available on our website too. And feel free to contact us with any questions. So we look forward to hosting another webinar soon. I think we got one coming on cybersecurity, right, Sean?
Very soon.
That's right. Stay tuned for our cybersecurity fans.
All right. Thank you.
Thank you.
Thank you.